Yeah, absolutely. As Barry mentioned, there may be some roadblocks on the way to that prison sentence. Former President Jacob Zuma, as we know, has until Sunday to hand himself over to start that prison term. His sentence imposed by the Constitutional Court is for contempt after he refused to obey their order for him to appear before the State Capture Commission. The judgments of the Apex Court cannot be appealed, as it's the highest court in the land. Yet today we hear a new term, the rescission of judgment. Let's get an understanding of this and the other legal process that's underway around Jacob Zuma. I'm joined by Tyrone Maseko of Team Maseko Attorneys. Tyrone, thank you so much for your time. So there are two legal processes. Let's start first with this application to the Constitutional Court for a rescission of the order. What exactly is it? On what grounds can it be used?
Okay, so a rescission of judgment is something which we generally use in the lower courts, so either in the magistrates' courts or in the high courts. And what it is in an instance where you've got a plaintiff and a defendant, and you've got someone against someone, they haven't defended the matter for whatever reason, and subsequently you get the plaintiff gains judgment. But having gained judgment, the defendant later learns that, oh, I didn't know that there actually was this action. So I had a defense to this action. I now want to bring an application to set aside this judgment that's been given against me. And the court will then ask me to show that there's a good reason why I didn't defend the matter. That's the first instance. And in the lower courts, you basically have 20 days to do that without going into much complication. And the second requirement is that you have to show good cause why it is that you did not defend the action. And that's where the tough bit is. What's interesting here is we're dealing with the Constitutional Court judgment, which is the highest court in the land. And it's a bit complex because you also have features of civil law and criminal law, in that it's a criminal finding that is imposed on a sentence that's been imposed, even though the process itself was a crime.
I did see that Pierre de Vos, constitutional law expert, took a screen grab of the part of the Constitutional Court Act that speaks about the rescission of orders as it relates to the Constitutional Court. So my understanding from what you're saying, it's basically you're saying, look, there was a mistake made, and I have to tell you about it, which is going to change everything. Any idea what that might be when it comes to the Zuma judgment?
Well, it gets complex, Sally, in this matter, in that we have here the Constitutional Court sitting as a court of first instance, so meaning that the matter was first heard by the Constitutional Court. And the Constitutional Court generally deals with appeals, matters that have been heard in lower courts already. It's very rare that it hears matters directly from in the first instance. And in this case, it's even worse because it was also dealing with what would have been factual disputes, which is something that the court does not generally deal with. And so now it raises the question of, well, should this thing be heard? But what's even more interesting, Sally, is that the court actually gave Jacob Zuma ample opportunity to present his defense. So it's not that we can argue that I did not know that this case is going on and I've got the opportunity to defend it. So he blatantly refused to participate. And remember, that's the first requirement you got to show, that you are not in willful default when you did not defend. I don't think Jacob Zuma can get over that hurdle. So I suspect that the court is actually not going to even listen to this petition and will just reject his request for an application and not even hear the matter at all, purely for the reason that he was given opportunity to present this case and he simply refused to do so.
Could this be another stumbling block? And we haven't even moved on to the second thing in the Pietermaritzburg High Court, but the Deputy Chief Justice, Raymond Zondo, of course, who Jacob Zuma has a problem with, which is the reason he says he didn't want to go or continue his testimony at the State Capture Commission, because he says Zondo is biased. He is now the acting Chief Justice because Mogoeng has gone on long leave. So surely this matter will have to come to the Constitutional Court. Will it present a conflict that Justice Zondo is now the acting Chief Justice of the Constitutional Court? And if so, should he be recusing himself?
Let's casting the net very, very far ahead. I mean, we're a long way off. There's not even a guarantee. So first, we've got to have a conviction in this Pietermaritzburg matter. Secondly, who knows what the composition of the Constitutional Court will be at the time. I mean, the matter would have to go to the Supreme Court of Appeal. And remember that you don't have an automatic right to appeal to the Constitutional Court. The Constitutional Court has got to decide if the matter gets there, whether it's even in its interest to actually listen to the matter. The Constitutional Court has been very reluctant to hear matters which are disputes of fact in criminal matters, purely because it believes that the trial court is better placed to assess the evidence. So I seriously doubt that this matter, if Jacob Zuma were to be convicted in Pietermaritzburg, would actually end in the Constitutional Court, but who knows what will happen. But they may take their chances in petition, but I think it may be dismissed purely on the grounds that it has no prospects of success, should it ever get there.
All right, so let's deal with the second issue, and that, of course, is what's going on in the Pietermaritzburg High Court, which I understand both have been lodged today. But what's happening in Pietermaritzburg, it's the application for a stay on the order of his arrest and imprisonment. Is that kind of a stopgap so that he doesn't have to go to prison on Sunday, so that the Constitutional Court rescission application can go ahead? Just talk me through the importance of these two parallel processes.
Yeah, well, I find it bizarre, Sally. I'm not aware of a provision in our law that allows a lower court, in this instance the High Court, to basically suspend the order of the Constitutional Court, which is the apex court in our land. So that, for me, is very, very absurd. I don't know what the grounds are for it. It makes absolutely no sense. They've always been given by a higher court. Well, I say higher court, the Constitutional Court. So the High Court has got no jurisdiction to hear such an application for stay, as far as I understand the law.
All right. Well, thank you so much for chatting to us this evening. That was Tyrone Maseko of T. Maseko Attorneys, talking to us about the twin legal processes that are now underway, or attempted underway, on the part of Zuma's legal team.